Welcome back. You're watching Politics Tonight, digging beyond the headlines. And now to our interview with the second guest of the day. I am joined by a constitutional lawyer, Vincent Otaokpupku, for discussion on the Ideato rep seat issue and matters arising. Thank you so much for joining us, Mr. Vincent.
Thank you for having me.
The Imo State National and State House of Assembly Election Petitions Tribunal has nullified the election of House of Reps member Ikenga Ugochinyere of the PDP. What's your reaction to the verdict?
Thank you for the question. There is no gainsaying. The fact remains that the judgment of the Election Petition Tribunal has provoked an exciting scholastic disputation, ranging from contentious issues and responses, because the judgment seems to have been given outside the provisions of the law and the age-long principles established by the Supreme Court. Section 134 of the Electoral Act prescribed the grounds upon which election of any candidate elected can be challenged. And it says, election can be challenged on the following ground: that the person whose election is questioned was not qualified to have contested the election at the time the election was held. Secondly, that the election is marred by corrupt practices and non-compatibility with the provisions of no compliance with the provisions of the Electoral Act. And thirdly, that the election, the person that was declared winner did not get the lawful majority of lawful vote cast in the election. And this provision, the Supreme Court have interpreted it in litany and cornucopia of cases, that the Election Tribunal, whose jurisdiction is circumscribed under this section, is not permitted by law to go outside this provision in case of cause of action or jurisdiction. Now, the fellow, after the 25th February National Assembly election in Ideato North, the candidate of the All Progressive Congress, Mr. Abazu, approached the Election Petition Tribunal in a petition marked EPT 10, petition number 10, and on two grounds. One, that Mr. Ikenga, Honorable Ikenga, was not qualified as at the time election was held, on the ground that the primary election that produced him as candidate of PDP was not valid, on the ground that it was held at Aladema Hall in Owerri, outside the constituency of Ideato North and South Federal Constituency. Secondly, he also challenged the person because he listed INEC as a respondent number 1, Ikenga 2, PDP 3, then 1 Pascal Chigozie Obi, candidate of Labour Party, as number 4th, and the Labour Party as number 5th. So this is what he challenged for PDP and Ikenga Ugochinyere. For the other fellow who came second in the general election, that is Honorable Chigozie Obi, he alleged that the fellow who was then a member representing the state constituency in the National Assembly was, at the time of the election, not a member of Labour Party. He alleged that the fellow defected elected on the platform of Action Alliance and on the floor of the House, defected to APC. And as a member of APC, his secretary went and contested primary election in PDP and Labour Party. As at the time he was doing this, that he was still a member of All Progressive Congress. That is the cause of action, grounds of a petition subscribed in the judgment, which I have here. Now, beyond this point, the question is this: can the issue of Ikenga Ugochinyere, the primary conducted by PDP that produced him, that was held in Aladema Hall Owerri, does that constitute a ground that can be used to challenge and nullify general election in this context? The answer is no. When you look at section 84, subsection 14 of the Electoral Act, it says that notwithstanding anything to the contrary in this Electoral Act, an aspirant who feels that a provisions of the Electoral Act or guideline of a political party or constitution of the party has not been complied with in the selection of the candidate in the primary election should approach the Federal High Court for redress. Please, for emphasis, an aspirant. Now, Supreme Court have interpreted this provision in litany and cornucopia of cases, but permit me to mention just a few. In the case of the locus classicus case that the Supreme Court established this principle was in the case of Okafor, then Dahatu and Turaki, Ado and Nyako, then PDP and Seva. There are so many other cases the Supreme Court have established that for you to challenge the primary election of a political party, be it nomination, be it purchase of form, be it delegate that are supposed to vote in the primary election, be it the venue, because you are questioning the venue the political party conducted their primary election. So all these things surround as pre-election, primary election dispute. It is only a fellow who participated in the primary election with all other aspirants in question that has the locus standi, the authority, the capacity, the constitutional virus, the statutory power to challenge.
Mr. Vincent, I would like us to take these actions one after the other so we do not get confused. Now, if the tribunal ruled that Ugochiri was not validly nominated by the PDP to contest the election and ordered supplementary poll in 55 polling units where elections did not hold, are these not valid reasons for the verdict?
Yes, like I've said before, the tribunal held, I'm trying to lay foundation, that the tribunal held that he was the primary election, he was not validly nominated on the ground that the primary election that produced him, conducted by PDP, was held outside the constituency designated, contrary to the provision of Section 84, subsection 5C, I and II. But if you allow me to interrogate this in further, having juxtaposed this with the judgment of the Supreme Court I have cited here, because judgment of Supreme Court binds inferior court, including the Electoral Tribunal, by Section 8287, subsection 1 of the Constitution. The Supreme Court said that each judgment by every person and authority on the Federal Republic of Nigeria shall enforce judgment of the Supreme Court and is binding on all parties, including the Election Petition Tribunal. Judgment of Supreme Court are not given just for mere giving sake. It is all to be obeyed. So the judgment was brought to the attention of the court, but the court refused to be abided by this judgment. Now, if you look at the case of Mrs. Anthony Tabansi-Okoye versus Blindi Bazo, Supreme Court established this thing to say that issue that has to do with the party politics, primary election, venue, all these things, is an internal wrangling between contending parties within the political party. And an outsider is a medicine interloper and cannot be heard to complain that a political party breached their constitution, a different political party breached the constitution, or what have you. Then, if you look at the recent case of Senator Ayo Ogweze versus PDP, Ayo Ogweze participated in primary election in a suit he filed in the Federal High Court in Enugu in 2014, a generation. He said that I participated in primary election sanctioned by Federal High Court judgment of Enugu State, as conducted by the chairman of PDP in Enugu State. That I did not participate in the primary election sanctioned by the national body of the PDP, by the committee appointed by the national body, headed by Asari Asara. So if the Supreme Court said no, by this mere statement of fact, you have taken yourself outside the people who can question the conduct of primaries conducted by the national body. You cannot question because you did not physically participated in the election. In this context, when you now look at this scenario, does the fellow that brought this action before the Federal Election Petition Tribunal has the locus standi to sue? The question is no. Outside this, when you look at section, the tribunal seems to have imported the doctrine of continuous injury in law. Continuous injury means that actions and injury is still continuing. And the Supreme Court have abhorred this principle and abolished it, that it does not apply in election matters. In the case of Honorable Nedi Nwoko versus Peter Nwabushi, where the Supreme Court said continuous injury does not apply in election petition on the ground of it has been abolished by section 285 subsection 9, which says not to stand anything to the contrary of the Constitution. Every pre-election matter must be filed 14 days to the course of action or the complaint of decision, complaint of, it must be filed in court. This action ought to have been filed at the Federal High Court as pre-election dispute, because the primary election of the Produce Ugochinyere was held on the 25th of May 2022. Now, this suit was filed after the general election of 25th of February 2023. So it is statute bad. And in the case of APC, ANPP and Goni, Supreme Court said that when a time fixed by law has expired, that a time fixed by Constitution is like Rock of Gibraltar and Mount Zion and cannot be shaken or moved. So,
all right. So Still on the issue, Mr. Vincent, still on the issue of the primary, the tribunal said the PDP primary that produced Gochinyere did not comply with provisions of Section 84(5)(c) of the Electoral Act 2022. So how does this affect Gochinyere?
That provision, if you look at that section section 84(5)(c), 1 and C, it is not mandatory. The Court of Appeal in so many cases have handled in Anambra because Anambra elections were taken to Oka because of insecurity, as the case may be. Now, the court held that it is not mandatory, it's directory. Now, the court invoked the principles of a doctrine of necessity, which is a constitutional doctrine that seeks to legitimize or validate extra constitutional situation to promote and preserve political stability. So the principles of doctrine of necessity is that the election could have taken place in Ideato because of a far-reaching problem of insecurity that was very pronounced. That reason why the party, because you have to save life. INEC monitored it under Section 84 of the Electoral Act, and INEC is still complaining. They listed him, he participated and won the election. Now, it does not affect him per se because he has a constitutional right to appeal, and which he's about to do. The law, Section 138 of the Electoral Act, has provided procedure for appeal, and he should remain in office, enjoy the benefit of his office until the time allowed to appeal has elapsed. In this context, when you look at the judgment of the court that purportedly seems to have sacked Gochinyere, at page 32 of that judgment, look at what the court said. You're fantastically surprised to read this. He said, we agree with the submission of counsel to the fourth respondent, that is the fellow for Labour Party, that the issue of membership participation in the primary election of political party can only be challenged by members of that political party, and more specifically, participants in the primary. The said challenge also ought to be done within the statutory period of 14 days, which puts it squarely in the purview of pre-election matters. See Section 84, which I've started before, Electoral Act as amended, and 2859 and 14. The petitioners have once again failed to ventilate these grievances at the appropriate time, forum, and now seek to surreptitiously do so before this honorable tribunal, which is not allowed by law. It is our view that having resolved that it is a primary matter, it is pre-election matter, all other issues thereunder have become academic. However, in determining the merit of the issue, as argued by the parties bordering on qualification of fourth respondent, on the basis of membership of the fifth respondent, Labour Party, the start-up point is to determine who has the right to challenge the membership of another political party. The simple answer is that it is a member of that party. The petitioners, which is the Abazu, in this case are simply meddlesome interlopers and have no locus standi. The court, the same judgment declared sacked Gochinyere. This is the court responding to the challenge to Labour Party candidate who came second in the election. Now look at it, out of common sense and decency. The court cannot, a fellow that came third in the election, scored 2,000-something votes, came third, won only in one polling unit, went to file action to nullify the nomination of the person that came first and the second, so that to pave way for him to climb the distance.
Mr. Vincent, before we move on,
there is another judgment. There's another judgment that the court delivered on the same day, because the same Honorable Pascal Chidozie Obi filed action against the same Gochinyere. The court marked the same judgment, the EPT 01. Judgment was delivered in that same petition on the same day. If you look at page 32 and 37 and 8, of that judgment, I don't have it here, but I've read it. For 7 and 8, the court said that the issue of membership, him defecting to APC at the floor of the House, constitute, under Section 65 of the Constitution, constitutes a pre-election matter and the borders of membership for political party, which the court does not have power to inquire, which I agree with the court. Relying on principle in Anyanwu and Ogunleye by the Supreme Court, Joag SN versus PDP. Supreme Court said membership for political party is an internal affairs of the party. No member or outsider cannot question it. The tribunal, I actually agree with them. So why the tribunal, in the same judgment, in the same suit, just somersaulted to now invalidate and detect and constitute the grounds that challenge Gochinyere's nomination as post-election question, on which it was used to nullify the exercise.
So, Mr. Vincent, before we get to the other issues attached to this case, Are you also saying that this case shouldn't have been entertained by the tribunal?
The court lacks jurisdiction. The court lacks the virus, the jurisdiction. The grant of the petition is incompetent and ought not to be entertained at all. The court in Nigeria should not look at technical justice. The Supreme Court have won over time that the court should not look at technical justice because he said that spirit of justice does not reside in its technicalities. Law is nothing but handmaid of justice. I'm quoting Supreme Court. That phraseability, which almost became a rule of law, often serves to render justice grossly. The most fundamental role of a judge is to dispense justice. Justice in this case that people of Ideato voted who they wanted to represent them. And the man has been sworn in. And the fellow that came third, that one-on-one polling unit, went to challenge him on the ground of venue of primary election. There is no gainsaying. There is no authority to support the action of the court. I have cited another judgment of the court where they said it's a pre-election matter. They cannot question it. Filed by a fellow that participated, a fifth responded in this judgment against Udechinyere. So how manage? The court blowed hot in this side, the other side it blowed cold in the one judgment or one constituency, two judgments arising from one election. So the court in the final analysis should, business of the court should allow the interests of the people, allow the public policy, public interest of the people to reflect in the judgment of the court.
So, Mr. Vincent,
how to vote.
Out of the issues like party primary venue, irregularities in 55 polling units, among others, which one do you think did more damage to Ugochinyere?
Sorry?
Did you get my question? Out of the issues like party primary venue, irregularities in 55 polling units, and among others, which one did you think did more damage to Ugochinyere?
The issue of irregularity in some polling unit has not been proven. The petitioner did not prove it. It's a question of proof. Issue that has to do with corrupt practices and non-compliance. It is not the court is not for a Christmas when you come, it just give you. It has to be proved by credible, compelling, and cogent evidence. You must call witnesses from the polling unit that is alleged, so the primary evidence will be generated for the court to rely on. You don't just say that there was this one, that you have to establish it. In this case, this man called, I think, only 10 witnesses or thereabout. He called only 10 witnesses. No, not up to 10. He called up to 5 witnesses. 7 witnesses he called for the entire Ideato federal constituency. So there's no way he will say, this, it's not possible. To that extent, there is no, the damage the court has done is much more viewed from the perspective of having purportedly nullified the nomination, looking back to exercise that took place on the 25th of May, 2022. That is the venue of the primary election. You cannot by any... Okay, the tribunal that is sitting in this case ought to be sitting in Owerri. But judgment of the tribunal is delivered in Nasarawa State, the Manaba, after Abuja. What concerns the tribunal that ought to sit in Owerri in Nasarawa is because of doctrine of necessity. For overriding public interest, for the issue of great insecurity in the state, they apply to be moved. It's safer for them to sit in Nasarawa. How come?
All right, so Mr. Vincent,
even if there's any problem in that day of primary election, that the people should still go there and vote.
How will you react to people?
What am I saying?
So how will you react to those calling for the review of the Justice Anthony Akwobi-led judgment? Is that practicable?
Constitutionally speaking, it is not practicable. When a court has handed down judgment, the only aspect that is left is for a fellow against whom judgment is delivered to exercise the constitutional right of appeal, which in the context is already in the pipeline. So there is no way a court that gives judgment will review it. It's not done. Unless there is any clerical error or mistake that the court want to contest. But what I'm saying in essence is this, that justice must not only be done, but expressly seems to have been done, convincing another man on the street, especially on the street of Ideato, North and South Federal Constituency, that justice has been done. So that woman, Mbonko and Mbafo, on the street, who crawled and used walking stick to come out to vote that day of a candidate of his own choice, the court cannot take that away from them. The court cannot take the choice of the people away from them. For constitutional democracy to stabilize, for political stability in the country, the court must seek to reflect the wishes of the people, the mandate of the people. The choice of the people must reflect in our judicial adjudication, in the judicial actions and activities. People can come to court and allege whatever you want to allege, but the end of law must be justice. And in this case, I do not see justice in what judgment of the court. I don't even see application of the law to the factual situation that transpired. Ordinarily, the court ought not to have entertained that application before them, which ought to be at the Federal High Court. Because if you thank God the court quoted section 8414, quoted 29C, which is on false information, quoted section 285 subsection 9 and 14. And when you look at section 289 subsection 14, it describes what is pre-election matter. A candidate aspirant challenging action of his party, a candidate challenging action of INEC, or a political party challenging action of INEC disqualifying their candidate. That is A, B, and C of section 285, section 14 of the Electoral Act. The court, stated all this provision. How come? Having raised appraisal of the law, having appreciated the law, regretting this course of action, you still digress. You see when, I wouldn't know what transpired. So it's a great injustice to the people of Ideato North and South. And I believe at the appropriate time, a court of appeal on the face of the judgment that have done before in so many and litany of cases. Because the case I cited, the Honorable Mrs. Antonia Tabansi Okoye versus Lindy Bazu, was handed over by the court of appeal. To say that you cannot, as an internal land-grabbing within party, come from outside. Even the Supreme Court, in the case of Mama Taraba, Mama Taraba case, Supreme Court said, you cannot come from another political party in the governorship court.
So Vincent, thank you very much. All right, thank you so much. I've been speaking with...
Thank you very much.
Right, I've been speaking with the constitutional lawyer, Vincent Otaokpupku, for discussion on the Ideato Rep seat issue and matters arising. Thank you so much for your time on Politics Tonight. Thank you.